Hello, my name's Nigel George. I'm the partner in charge of life planning at Garner and Hancock Solicitors in Isleworth. Life planning is all about, as it says, planning for your life, making sure that you put arrangements in place so that if something unforeseen happens, your family and those that you love are properly looked after. So today we're going to go through a few points to consider when making a will. One of the first things that people need to think about when somebody dies is organising the funeral and how it's going to get paid for. Normally your executors, if you have a will do it, or close family members, but it's your executors obviously who have access to your funds to do this. Banks will normally release money for the purpose of paying for a funeral, and also whether you've got any particular wishes which may have been recorded. A lot of people don't, but it is a good idea to have some clear wishes in terms of what kind of funeral you want. People often get confused between wills and lasting powers of attorney. A lasting power of attorney, and there are two forms, health and finance, these deal with your affairs while you are alive. They come to an end when you die. Your will is the document which sets out what happens to your property and your money when you die. It's really important document to have in place because it allows you to choose who is going to inherit your estate. If you die without a will, then the intestacy rules come into play. Now, these were first established back in 1925, which is almost 100 years ago now. They don't take account of the way people live today. The only people who will inherit under the intestacy rules are your spouse or civil partner and your children if you have them, and if you don't, it is more distant blood relatives who will stand to inherit. It's totally haphazard. You have no control over who may be inheriting your assets, and therefore it's really important that you have a will. It can also result in inheritance tax becoming payable when it wouldn't be payable if you had a will. You may have been living with somebody for 20 years or more. Lots of people these days don't see the benefit of getting married. But unfortunately, the laws on wills and intestacy haven't changed with current habits. If you are not married or in a civil partnership, the law tends to treat you as if you are total strangers, and a partner will inherit nothing. They can look to bring a claim under the Inheritance Provision for Family Independence Act 1975, but that can involve them in having to go to court, which can be a very expensive and time-consuming affair. Inheritance tax is a tax which you pay on death. It's 40% on all of your assets over certain given thresholds. So, for example, if you are a single person without any children, then all you get is the basic allowance of £325,000. If, however, you are married, have children, own a house, then you can leave assets up to £1 million without incurring inheritance tax liability. It's important that a will is clear. You may understand what you mean by I leave my diamond ring to Sadiq, but will other people, particularly if you have, say, a number of rings? It's important it's clear. It's also important it is not too specific. So, for example, you might say I leave my sports car to Fred. But what happens if you don't own a sports car at the time of your death, and in fact perhaps you own a Land Rover instead? So it's important to think ahead in terms of what you may have. We advise people when making wills to keep them as flexible as possible and as generic as possible. If you're looking to give somebody a large sum of money, then perhaps just think about giving them a proportion of whatever is left, as opposed to a specific item which you may no longer own when you die. Often a house is the biggest item that a person has, and they may want to leave it to a specific relative, a son or a nephew, and then they may say, well, I've got a few pounds in the bank and I'll leave that to my friends. But the problem is, what happens if you don't own that house when you die? I had a situation recently where a will left a house in equal shares to a brother and a sister, and everything else, what we call the residuary estate, just to the sister. It had been the intention of the parent that the big asset was shared between the two children. But unfortunately, at the time that the person passed away, they no longer owned the house. This meant the son got nothing and everything went to the sister. So again, this is the problem with specific gifts, that can be a problem. Far better to leave somebody just, the majority of your residuary estate, so that you can be sure that they are going to inherit something. Your executors are the people that you appoint to administer your estate after you die. This is a really important role, particularly if you have got young beneficiaries where funds may need to be managed. It's important that your executors are going to treat everybody fairly. There can be problems sometimes if you appoint one child and not others, particularly if they don't get on. We've had frequent examples of where siblings have treated one another very badly because they've got that power of control over the assets. So you do need to be careful who you appoint. And if your executors are not a beneficiary, leave them something in your will. Many people don't, but it is quite an onerous thing. Even if you've appointed solicitors to deal with it, there's still a lot for an executor to do, and it really is important that they are rewarded in some way. Unless you say anything to the contrary, a beneficiary will inherit at 18. This is a really young age for somebody to inherit a substantial sum of money. We normally recommend that they don't inherit money outright until they reach the age of 25. Now, the will can provide for money to be given to them before then, but they don't have total access to it. And there again, this comes back to the question of having executors who can properly manage money on people's behalf until they get to an age when they can fully understand what £100,000 or £200,000 actually means. People often worry about having to pay someone's debts when they die. Demands can come in for money, credit cards, repayment of pensions, and a number of other things. As an executor or a beneficiary of somebody's estate, you have no liability beyond their assets. But that's important. So if somebody dies with £20,000 in the bank and they've got, say, £10,000 worth of debts, well then that £10,000 of debts has to be paid out of that £20,000. But it's purely limited to what assets they have. You have no personal liability at all yourself. Leaving money to charity can be a really good idea. I mean, often, again, single people who've never had any children may find themselves in a situation of having quite a large estate. And a really good way of limiting the amount of inheritance tax is to leave gifts to charity. Gifts to charity are totally free of inheritance tax, and even if you only leave 10% of your estate to charity, then it reduces the tax rate from 40% to 36%. So it's a very good way of seeing that money goes to good causes such as the Mulberry Centre and other charities when you're going to be facing paying inheritance tax. And again, in a will, it's choosing for your money to go where you want it to go. And that's the really important thing about making a will. It's you choose, you decide what happens to your money, not other people.